correct about what caused the graze wound in his arm, did you take into account that an abrasion could have been caused by flying glass inside the car that he was sitting in?
I considered that glass might have caused an injury to his arm.
Okay. You did consider that?
Yes, sir.
Did you consider that he could have hurt his arm or scratched his arm falling down on the street?
Certainly, you can scratch your arm from falling.
Okay. And in fact, you specifically used a skinned knee as an example of an abrasion earlier in your testimony, correct?
That's correct. When you fall, typically you hit pressure points, so you would hit elbow, knees, shins, that kind of thing.
Doctor, you indicated that you watched some of Mr. Frier's testimony on video. Did you happen to watch the portion of his testimony in which he was describing to the jury the position of his arms at the time he thought the shooting took place?
I believe that is it was about an hour long. That's the segment that I actually watched.
Okay. And approach with the show?
You may.
Do you recognize that, I guess it's really a capture of a still?
Yes, sir.
All right. And that's Mr. Frier actually in that witness box testifying or on the witness stand as part of this case, correct?
I believe that's what it is, yes, sir.
All right. And fair to say that in that particular image, he appears to be demonstrating something. Is that correct?
Yes, sir.
Is that among the things that you took into consideration when you watched and viewed his trial testimony in this case?
Yes, sir.
All right. Your Honor, at this time I'd offer that as the next exhibit.
No objection.
Without objection.
Reading.
Showing you what's been admitted as exhibit number 389. Doctor, did you take that into consideration when in determining whether Mr. Frier was correct about whether the inside of his forearm had been grazed by a bullet?
I considered his position, his relative position, that captures him on the stand going through what he's recalling now.
Okay. Now, the chart that you created in connection with your work on the defense case also has Mr. Frier positioned in the middle of the back row, correct?
That's correct.
And the way you have him positioned in that is with his arms directly in front of him, outstretched. I don't know, was it palms down or palms up?
I didn't really put that either palms down or palm up. What I did was look at that point in time, the shot I knew had to come to his right arm and lodge there. Again, that one comes back to the back shot, ends up starting as the arm shot to Mr. Furtado. So that's all one line. So that allowed me to say, okay, this arm has to be relatively up. Again, I don't have the vehicle, which would be ideal to position it exactly, but that's what I'm working with to position that arm. The left arm I positioned because I know I've got this graze wound here. And that, again, I account for by that sixth shot. You asked me earlier if there are other possibilities. There are other possibilities for another sixth shot.
So, Doctor, so when you positioned Mr. Frier with his arms forward, you're not suggesting that that's the way he was sitting. You're suggesting that his arms were forward of his body, relative to his body, correct?
Yes, sir. That's correct. And
All right, the answer is yes.
yes, sir.
Thank you.
And Doctor, when you just demonstrated that the position now, you had your left hand with your left hand facing the right, correct?
Correct.
All right, and that would expose the inside of the forearm to the person's right. Is that correct?
That's correct.
All right. And you realize that the graze wound was to the inside of his forearm, correct?
It was to the front of his forearm.
To the front. When you say front of his forearm, what do you mean? Could you point on your body?
Again, anatomic position, as you were positioned, it would be rotated, so it would be the inside in this position. But anatomic position, this would be the inside.
And so, as you just had it, with the left hand facing to the right, with the front, did you call it the front of the forearm? I'm sorry.
The front, yes, sir.
The front of the forearm also facing to the right. You'd agree with me that if gunshots were being fired from the right, his inside forearm would actually be in the line of fire, correct?
Depending on where that forearm is positioned, yes, sir.
So a bullet coming from the right, approaching the inside of somebody's forearm, actually wouldn't graze it, it would actually hit it.
As you have your arm positioned, yes, sir, it would. That's what I meant about motion. It depends on when that shot occurs.
Well, that's how you had your arm positioned, Doctor. I was just doing what you did. Isn't that how you had your arm positioned?
I was just doing what you had me look at, sir.
Did you take into account this version of events from Mr. Freire? That is what's shown on 389 when you considered whether Mr. Freire could have been right or wrong about having a graze wound caused by a bullet as opposed to broken glass, falling down, or anything else like that?
Again, glass causes incisions, not abrasions, but I did consider reasonable possibilities, such as possibly falling down, that type of thing.
Now, you also mentioned that your belief or your opinion was that the graze on the inside of Mr. Freire's forearm possibly could have been caused by the exit wound or the exiting of a projectile from Mr. Furtado's head. Is that correct?
That's correct.
Okay. Now, did you review Mr. Haig's report in connection with the shooting reconstruction that he did?
Yes, sir.
All right. And other than some issues that you took with some of his medical assessments, you found his ballistics analysis and his shooting reconstruction analysis to be quote-unquote valid, did you not?
Generally valid, I believe, was
Well,
the term I used, and I wouldn't rely on a layperson to have medical opinions.
All right. So leaving aside the medical opinions for a second, Doctor, did you not say, in general, as regards his non-medical findings, Mr. Haig's reconstruction is valid, correct?
That's what I just said, yes, sir.
You're aware that Mr. Haig's reconstruction has the bullet exiting Mr. Furtado's head as striking impact areas B and C in the vehicle. Do you remember that?
That is, I believe, one of his opinions, yes, sir.
Okay. And that the jacketing that was found on the back seat of the car, as well as the piece of fragment found on the left elbow rest, you're aware, sir, that Mr. Haig concluded that that was a candidate for the projectile that struck impact sites B and C, correct?
That's correct.
And that the fragment that was found on the left elbow rest had embedded glass in it, correct? You remember that?
It had scoring on the surface, excuse me.
And embedded glass.
I believe so, yes, sir.
Okay, and no blood.
I believe that's correct.
So that was on a completely different trajectory, wouldn't you agree, than the one that Mr. Freire was in the line of?
I'm not sure I'm following you in terms of this position.
Well, what I'm asking you is that you opined to this jury that one of the possible causes of the graze wound to Mr. Furtado's left arm was the projectile that exited Mr. Furtado's head.
That is a possibility.
Okay. And when you say it's a possibility, did you take into account Mr. Haig's report that you found to be valid that suggests that that bullet was on a different trajectory than the one that Mr. Freire was on?
Again, I said generally valid, non-medical.
Okay, so you have an issue with that aspect of Mr. Haig's report? Is that what you're telling us?
I'd have to see exactly how he phrased what he phrased. Generally, he accounted for 5 shots and said there could be a 6th, and I believe that clearly the evidence shows that there are 6.
Okay. And that's if you believe that Mr. Freire is correct that that graze wound was caused by a bullet, correct?
Well, there's other, again, you asked me if we exclude that, are there other ways to account for 6 shots? And yes, there are. Easily.
You called the injury to Mr. Freire's arm, inside arm, as having been caused by, quote unquote, the 6th shot, correct?
That's correct.
Okay. So if he's right, if he's incorrect about what caused his wound, there would be no 6th shot in that context, correct?
No, sir, that's not true.
The 6th shot that you referred to was a reference to the bullet that purportedly or supposedly caused the wound to Mr. Freire's inside left forearm, correct?
I believe that's, if I'm following your question, I believe, could you repeat it for me?
Well, it's in your report. You called that shot the 6th shot.
Based on the totality, let's say, for example, yes, sir.
Doctor, all I'm asking you is whether you referred to the shot that you allege caused Mr. Freire's wound on the inside left forearm was the shot that you called the 6th shot, correct?
The objection is sustained. I think the witness answered that in the last response. That is what you wrote.
Yes, sir, that is what I wrote.
Very good.
And therefore, if Mr. Freire is incorrect that that wound was caused by a bullet, there would be no 6th shot in that context, correct?
No, I don't believe it has been.
If you're asking if that was not caused by a bullet, there's still a 6th shot.
And that 6th shot that wasn't called by a bullet, even though that's what you did call it, the 6th shot that injured his left forearm, the other 6th shot now is the bullet that you're alleging came from the exit wound in Mr. Furtado's head?
No, sir, I have to account for the projectiles in the car. One of the projectiles fragmented. That fragment either went one way or the other. It's not going to do both. If that bullet fragmented and caused this injury, then another shot track has to follow in the vehicle.
What fragment are you talking about?
Well, I don't have a specific fragment because the windows were open.
So you're saying if there was a fragment that never got recovered, that fragment could have caused the wound?
Well, we know there were pieces that weren't recovered.
Doctor, what I'm asking you is, are you telling this jury that the 6th shot is some imagined fragment that went out the window?
No, sir, there's no imagined fragment, sir. What I'm trying to explain is under the scenario that I've demonstrated, clearly shown the 5 bullets within the vehicle, there's a 6th shot. The arm is up there in the scenarios I've laid it out in my report. That's the 6th shot.
That's not what your opinion is in your report, is it, Doctor? Your opinion in your report is that the 6th shot is the shot that hit Mr. Furtado, or allegedly hit Mr. Furtado, on the inside of his forearm.
Sustained.
I have nothing further.
Is there any redirect?
Yes, sir. Try to be very quick, Sister. Mark, may I have the...
Dr. Downs, I'm back. Dr. Downs, Mr. Lee just questioned you for well over a half an hour about this graze wound. You looked at the grand jury testimony of Mr. Ferrer on July 10th, 2013?
I don't recall the date. I think I just saw grand jury testimony and about 4 or 5 lines.
Yeah, approach. Would you just look at this for yourself and see if that refreshes your recollection about seeing grand jury testimony, Mr. Ferrer?
Yes, ma'am.
And that was grand jury testimony from July 10th, 2013?
I didn't look at the date, but I'll take your word for it.
Okay. But you remember seeing this testimony, correct?
I remember seeing the part that I put on top of the stack as I handed it back.
And do you remember then reading questions to Mr. Freer by Mr. Hagan? By the prosecutors. You wouldn't know who's who.
Yeah, I don't know who asked the questions. I just remember like a question and answer response.
And do you remember seeing that the question was asked under oath in a grand jury to Mr. Freer, where did you get shot?
Yes, ma'am.
And do you remember him answering, seeing in my right arm?
Yes, ma'am.
And do you remember Mr. Freer getting asked by the prosecution, and did that bullet stay in your arm or did it exit your arm?
Yes, ma'am.
And do you remember reading, answer, one stay, one just pass, you know, just cross. You remember seeing that?
Yes, ma'am.
And do you remember seeing the question to Mr. Freer, sorry, say that again for the record? Answer, one bullet, stay inside. You remember that?
Yes, ma'am.
You remember seeing the question? Yes. And the answer, and another one, just, you know, just cut a little bit. You remember seeing that?
Yes, ma'am.
And you remember seeing the question by the prosecution to Mr. Freer, question, just grazed you?
Yes, ma'am.
And you remember seeing the answer, Mr. Freer, yes?
Yes, ma'am.
And did you take that into account when you determined that Mr. Freer, along with the medical records that you saw, had a graze wound to the left arm?
Yes, ma'am.
Now, with regard to your testimony with regard to the 6th bullet, besides a bullet, did you see anything that could have broken the glass in the left rear car of that BMW?
No, ma'am.
And with regard to your CV, sir, or your bio, which is 1 page, not your CV that you testified to, when you did those TV shows, was that when you were a medical examiner for various counties?
For various jurisdictions, I believe, Charleston, South Carolina, Mobile, Alabama, Savannah, Georgia.
And did those jurisdictions want or authorize you to do those TV shows?
Yes, ma'am. The last one
Hold on. Sustained.
Did you get permission to do those TV shows from the jurisdictions you were working for?
Sustained.
Sir, were you were there to promote yourself individually, or you were there to promote in those TV shows the medical examiner's office for which you worked for?
Overruled.
I was there to basically work for the office and the agency. We had police agencies as part of the same program to tell the story.
Okay. So it was not for your personal benefit?
No, ma'am. Actually, I'm kind of a private person.
Did you get paid any money for those TV shows?
No, ma'am. I actually did all of them while I was on salary, so I was paid by whatever jurisdiction I was working for while I was doing those, so they had full knowledge that I was doing it and full support. In fact, the last ones I did it for GBI, we were in the autopsy room at GBI filming segments of it, at the conference room at GBI filming segments of it. They had a hotel room that the Dateline was in, I think, and we had the investigative agent went before me, and they filmed all of that.
Okay. And that's not on your CV, that's on your bio, correct?
That's correct.
Okay. Now, with regard to another couple other questions that Mr. Lee asked you, were you aware, sir, that 2 men left the BMW and left the scene?
That's my understanding, yes, ma'am.
Were you aware, sir, that one, Mr. Sanchez, destroyed evidence to wit his clothes?
Sustained.
We were, sir, that Mr. Sanchez burned his clothes.
Sustained.
Sir, when you did this, let me have this marked, if I may.
For identification,
Yes.
show it to the Commonwealth if you would.
It's no picture, the picture's taken.
Okay,
No.
thank you.
Not as a chalk fish.
Judge, I intend to use it as a chalk fish, so open the door and toss it down.
I'll see you at sidebar.
Doctor, I'm going to show you now what has been marked for identification, LLLL. That's the exhibit that you had drawn under your tutelage at our request, correct?
Yes, ma'am.
Okay. Now, sir, the prosecution asked you some questions about that and about the placement of the arm. Sir, is there anything in your report that precludes Mr. Furtado from holding a gun as pictured in that exhibit, that drawing, excuse me?
Not at all.
Did you see anything medically that would prevent him from holding a gun until he was shot?
Not at all.
And you drew this at our request, correct?
I created that at your request. The parent images, if you will, were provided to me, and I then painted it from this.
And then, sir, when you went to the scene at Chalmette, did you see something that was interesting to you? Mr. Lee discussed you just going to the scene recently, correct?
Yes, ma'am.
And did you see something that was interesting to you?
Very interesting, yes, ma'am.
What was that?
As you come down Chalmette to Herald, the road dips as you're coming to Herald. And in addition to dipping, the left-hand lane dips toward the curb a lot. I noticed this, we were in the middle lane, and I could see the cars to my left were all angled.
Objection beyond the scope.
No, overruled.
Right. And what does that mean for your opinions that you gave today with regard to the ability of the shooter to require to have free arm movement?
Objection.
Sustained.
Did that hill affect your opinions in any way?
Yes, ma'am.
Objection.
Sustained.
Now, let's talk about the additional supplemental report that you did at our request. First, let's go to the original report. When you read questions for Mr. Lee, did he ask you whether you mentioned the exemplar shirt, which seems to have...
He didn't ask me about that, no, ma'am.
All right, and could you go to page 3 of that report?
I don't have it in front of me,
Okay.
but I probably can answer the question.
All right, well, let me walk up to you if the judge okay. I've only got a couple of minutes. Page 3, the last page.
First one.
First one. I'm holding also the exemplar shirt. Could you tell the jury what you mentioned with regard to the exemplar shirt?
Objection.
Grounds.
Seriously, gave an opinion in the court.
He questioned about what opinions was not in his report.
I can't hear
I'm sorry, I
you.
apologize.
The objection's overruled.
Could you read the ladies and gentlemen jury what you told all of us with regard to this exemplar shirt?
Bottom of page 3, quote, "The latter," that would be the right arm raised to approximately shoulder level. "The latter is confirmed by means of comparison of the decedent's shirt with an exemplar shirt with defects placed in the exemplar corresponding to the position of those in the decedent's shirt," end quote.
And sir, when you did your supplemental report, it was not an amended report, right? It was a supplemental report, correct?
That's correct. It supplemented the
The
original.
answer's yes.
Yes,
Yes.
sorry.
Thank you.
And that was after you sat here and listened to Dr. Lindstrom testify, correct?
Yes,
And your report indicated observations that you had regarding our testimony, correct?
yes,
That you conveyed to us, correct?
Yes, ma'am.
And you know that we were going to convey to the prosecutor.
Objection.
Sustained.
Did you change any opinions in your original report that discussed the angulation and the abrasion borders and the trajectory?
No, ma'am.
Did you change any opinions at all from the original report?
No, ma'am.
And sir, as you sit here after you were cross-examined by Mr. Lee, does anything that you were asked change any of the opinions that you testified to this jury this morning?
Objection.
No, overruled.
No, ma'am, nothing changed.
And were those opinions held within the reasonable degree of certainty that somebody who does wound analysis, reconstruction, and pathology holds?
Yes, ma'am, they were.
Thank you, Dr. Downs. I have nothing further.
Commonwealth?
Nothing else.
Thank you. Doctor, you may step down, please. Watch your step.
Thank you.
Could we take the item off of the screen
And I'll give it to Ann.
and collect our exhibits? Mr. Baez.
Yes, Judge. We have one composite group of photographs that we'd like to stipulate with Mr. Hagan.
No objection, Your Honor. They are duplicates of a lot of what we have, but we have no objection to a separate exhibit. Consistent clothing.
All right, these will be received as Exhibit 389. I'm sorry? 390. I've been off by one almost all trial. Exhibit 390.
And then, Your Honor, Mr. Hagan, ladies and gentlemen of the jury, the defense rests.
Commonwealth.
No rebuttal evidence, Your Honor.
No rebuttal evidence. Ladies and gentlemen, the defense has rested, meaning all the evidence the defendant deems appropriate for your consideration has been presented, and the Commonwealth is not seeking to present any further rebuttal evidence. That means the evidence is now closed. All of the evidence upon which you will deliberate to determine the facts of this case has now been presented. There are three remaining segments to this trial. The closing arguments of the attorneys, followed by my instructions of law, followed by your deliberations by 12 of the 15 of you. I think, as I told you at the beginning of the trial, which 12 that will be is not yet known, because we will draw 3 of your probably seat numbers out of a barrel to serve as alternates, and that's not yet occurred. That will happen tomorrow before deliberations commence. We are going to adjourn, as far as you're concerned, until tomorrow morning at 9 a.m., when we will hear the closing arguments of the attorneys, and then I suspect tomorrow afternoon the instructions of law that I will be giving you, and then 12 of you will commence your deliberations. Please understand, all the restrictions that have been in place throughout this trial remain in place. By that I mean, between now and ultimately, when you have returned verdicts or been discharged, you must avoid any contact with the case. You must avoid any discussion with the case other than by 12 jurors during deliberations, and you must avoid any outside contact with this matter. So between now and tomorrow morning, put the case out of your mind. Please don't discuss it, read, hear, or see anything about this case. Don't attempt to learn anything about this case on your own. Enjoy the evening. We'll see you tomorrow morning. It's my intention to proceed to closing arguments first thing tomorrow morning, likely hearing the closing argument for the defense and then having a recess of 20 minutes or so, then receiving the closing argument for the Commonwealth, likely then suspending perhaps for an early lunch. And during that period of time, to the extent either side wants to be heard on instructions, that would be an appropriate time. I don't want to keep the jury delayed from their duties to any significant extent if we can avoid it. With regard to the instructions that I will be giving the jurors tomorrow, I've considered and reviewed the requests made by both sides. I've incorporated many of the requests made by both sides, not all, but many, and I'm going to distribute a copy of the instructions in close to final form for both sides to review overnight. Let me say that I've considered whether or not it's appropriate to give a missing witness instruction in accordance with Section 1111 of the Massachusetts Guide to Evidence and reviewing appellate cases on that issue. I think most notably a case that stuck out to me is Commonwealth versus Salatino at 449 Mass 657, and I do not find that the foundational requirements of Section 1111 have been met to permit or require a missing witness instruction. I find that there are other factors or circumstances that could explain and would explain why certain witnesses were not called. What that means by way of missing witnesses is the defense is free to argue that the evidence presented at trial is insufficient to meet the Commonwealth's burden of proof, and in doing so may argue the absence of evidence, including the absence of certain witnesses. Counsel may not, however, go on to argue that because a witness was not called, their absence permits an inference that their testimony would have been unfavorable to the Commonwealth. As the SJC has stated in Salatino, there is a clear distinction between those two arguments and holds that while the first is permitted, that is commenting on the absence of evidence, the second, mandating or permitting an adverse inference, is not. I am going to distribute to both sides a synopsis of Massachusetts case law as regards what our appellate courts have talked about in terms of proper and improper arguments in closing arguments in Massachusetts. This submission is taken from Jury Trial Bench Book, 3rd edition, published by the Flashner Judicial Institute, and serves as a fairly helpful guide as to what is proper and improper in closing arguments. I'll also let both sides know that in advance of closings tomorrow morning, I may give the jury an instruction with regard to closing arguments. That instruction would follow the language of Commonwealth versus Finstein. And Ms. King, that's Finstein. Finstein found at 426 Mass 200. And it's pretty good guidance to the trial court by the Supreme Judicial Court. All right, is there anything else we should attend to now? Commonwealth?
We did file a motion, which may be taken care of by what the court just handed out, but we filed a motion relative to precluding certain impermissible
arguments by both
top ones. Voir dire questions were. The court, I don't think, ever gave a limit. Bias will again something that
have to hear what is argued in cause. If you feel that something is argued that is improper, or in the context in which it's argued improper, object at the time. I know that particularly experienced trial attorneys, and you are certainly one, don't like to object during the closing argument. But to ask me to rule in advance on what is permissible and impermissible depends in large part on the way in which it is argued and presented. So I'm not inclined to rule in advance.
Your Honor, I'm hard pressed to find a way in which it would be permissible to comment on the Commonwealth's voir dire questions.
Don't know, I'd have to think about that. And hear from Mr. Baez, I don't think I'll do it now. All right, anything else?
No, Your Honor.
Mr. Baez, anything?
No, sir.
See you all in the morning. Be prepared.